Good morning, and thank you all for joining us today for Bracewell's presentation, Caught in the Crosshairs at Work. My name is Rebecca Baker, and I'm a partner here in the Houston office of Bracewell's Labor and Employment Group. And I'm joined today by my associate, Christopher James, who is located in our Dallas office. We're glad to be here today to help you think about how to approach a topic that, sadly, is something more and more employers are contending with: violence in the workplace. Before we get started, I do have just a few housekeeping notes. First, I wanted to let you all know that the week of November 4th, we will be hosting a week-long webinar series with topics focused on the wave of state and local laws that are sweeping the country. With federal employment laws fairly stagnant, states and localities have decided to take matters into their own hands, and what emerges for employers are some fairly complex webs. In addition, we've seen some trends developing out of these new regulations, certain locations striking first and then others jumping on board. We plan to look at, among other things, new sexual harassment standards and drug testing and marijuana-related issues. So we'll be sending more detailed information closer to the time of the event, but mark your calendars for the week of November 4th. Next, if you have questions as we go through our webinar, please type them into the comment box on your screen. We'll try to get to as many questions as we can at the end of the webinar, and if we run out of time, we'll do our best to respond to those questions in a follow-up email. Lastly, we are very aware that you have taken time out of your busy day to join us, and we plan to be respectful of that. We will try our best to wrap up entirely in 1 hour. However, we wanted to let you know that if by the hour mark we are not quite finished and you would like to stay, the webinar will continue to run and we will finish up. All right, let's get to our topic at hand. Violence in the workplace. No employer is immune from it and no employer can totally prevent it. But hopefully with some thoughtful planning and some targeted policies and employer actions, you can potentially take steps to diminish the risks in your workplace and position your workforce for a strong response in the event it does occur. In addition to wanting to take these steps for the obvious human reasons that employers care about their employees as people, employers also need to focus on taking these actions because you're charged under the law with responsibility for ensuring a safe and healthful environment for your employees, which includes the protection from workplace violence. So if you stop and really think about this topic, there are so many different aspects to it. We really could take much more than an hour to delve into every detail. But given that what we have is an hour, the following is what we plan to cover. We want to understand the big picture. We'll speak a bit about what is workplace violence and what is the magnitude of this problem facing employers today. Next, we'll move on to ways that employers can start thinking about potential risk factors. What factors are universal to all employers? What special risks might your particular business have? Once you start thinking about and identifying those risk factors, it can help better position you to try to reduce that risk or at least be prepared to deal with the violence that might arise if such risk cannot be mitigated. The third portion of our presentation aims to give you some very practical advice regarding some best practices to create a safe work environment and minimize the risk of workplace violence. And then finally, we'll talk about preparing for and responding in case the worst eventualities come to pass. All right, Chris, I'll go ahead and hand it over to you to start getting into things.
Thank you, Becky. We all are familiar with different stories of workplace violence in the news. I just want to take time to highlight two incidents that touch on themes we'll return to later in the presentation. The first was the Virginia Beach shooting, which occurred on May 31st, 2019. This was a shooting at a municipal office in Virginia Beach. The day started out like any other workday on a Friday, and a longtime city engineer resigned in good standing. Later that afternoon, he returned to the building, accessed the offices using the keycard system, and opened fire using a silenced .45 caliber weapon and he ultimately killed 12 of his coworkers that day. Although the employee resigned, he resigned in good standing without any disciplinary history, and as a result, he still had a copy of his key card. Police arrived on the scene, and the shooter was eventually killed in a firefight. What I found eerie about this story was there was no clear motive. There was no disciplinary history, and he was not terminated for performance issues. Coworkers did not identify any red flags. They said earlier that day he was acting normally. The shooter had some past National Guard training, and he legally purchased his weapons. The next incident I want to touch on was in Aurora, Illinois on February 15th of this year. This also involved a shooting on an employee's last day of work, although this one was a termination. In this case, an employee worked at a manufacturing facility in Illinois for 15 years. After a series of workplace rule violations, he was called in for a termination meeting. At that meeting, the employee drew a pistol and killed the plant manager, an HR manager, and a college HR intern. The employee then entered the facility and began firing, killing 2 more coworkers and injuring a third. Police arrived on the scene, and the employee was killed in an hour-long firefight. 5 police officers were injured in the fight. That employee passed a background check when he was originally hired 15 years ago at the facility, and the facility did not pick up the employee's past out-of-state felony for aggravated assault in 1995. That same employee also passed the background check when he tried to obtain a firearm owner's identification card, which is required to purchase a firearm in Illinois. After he acquired his pistol, he applied for a concealed carry permit. That permit involved a more rigorous background check, which did catch his out-of-state felony. Illinois then revoked his firearm owner's identification card and sent him a letter asking him to return his weapon. The employee did not do so, and that was the same weapon he used to carry out his attack. While working at the facility, the employee was also arrested 6 times for traffic and domestic battery-related reasons. Moving on, we want to put the workplace violence into the context of the broader picture of workplace mortalities. This chart on the screen provides an overview of selected categories of workplace fatalities. You can see the different colored bars represent different categories of workplace deaths. We pulled data from 2011 to 2017 using information from the Bureau of Labor Statistics. As you'll notice, the yellow bar signals intentional violence in work and injuries, which is what we call workplace violence. And you can always see that in every year, workplace violence accounted for over 500 fatalities and less than 1,000. The overwhelming leading cause of workplace death is transportation accidents, represented by the blue bar. You can see that intentional violence typically comes in second, but is close to the number of fatalities for falls, slips and trips, and contact with objects or equipment. Other, lesser causes of workplace mortalities are represented in the graph, such as fires and explosions, and exposure to harmful substances. Moving on, let's break down workplace violence fatalities into their constituent parts. At the bottom of each bar graph, you'll see a yellow chunk representing workplace suicides. You can see that in every year from 2011 to 2017, workplace suicides account for approximately 1/3 of all workplace violence fatalities and range between 200 and 300 deaths per year. Next, in blue, representing approximately half of all fatal workplace violence injuries, are intentional shootings. You'll see that through the years, we have never had fewer than 300 workplace mortalities from intentional shootings. The remaining chunk of the bar, represented in red, are intentional injuries to another person using a device other than a firearm. This could include knife homicides, or killings using work equipment, or killings using any other weapon or method.
All right, those are certainly some tragic stories and statistics, but hopefully we can learn a bit from them. As you begin to evaluate the issues of violence in your workplace, it is helpful to understand that there are generally 4 categories of perpetrators in the context of workplace violence. First, we have type 1, which is unrelated, external, and intrusive violence. This would be a stranger with no legitimate connection to the workplace. It can range from something like a robbery type incident to the larger scale mass shootings that we have sadly seen recently. Risk factors for unrelated violence incidents include interaction with the public, open access to public spaces, the exchange of money, working alone or in small numbers, late nights and early mornings, guarding property, working in a mobile workplace, or working in high crime areas. And as you consider your plans and mitigation of workplace violence, remember not just to consider your own working environment, but your neighboring facilities as well. While you might not be generally open to the public or deal with customers, do you share a building with an employer that does? The next category is consumer-related violence. This is someone that does have a relationship of some sort to the business, but is not an employee. We're talking about your clients, customers, patients in a healthcare setting. And this can be caused by someone who is inherently violent, inmates, healthcare setting patients, or it could also just be someone that was triggered into a violent event. The third category is relationship violence. This is when we're talking about coworker violence. It arises out of that workplace connection, and it might be a current or sometimes a former employee. And lastly, we have our fourth category, which is external relationship violence. This is the perpetrator who is not an employee or a former employee of the affected workplace, but does have some type of personal relationship with the intended victim or their colleagues. The classic example is domestic violence that's spilling over into the workplace. And if you look at workplace homicide statistics, robbery-related workplace homicides are actually the most common, and that would be type 1. But the second most common cause of homicides is arguments, and the major percentage of those are either type 2 or type 3. So once you get a sense of the type of perpetrators you might be dealing with, the next step is to review the internal and external conditions that might heighten the risk of violence. Studies have identified several working conditions that contribute to workplace violence, but one of the biggest keys is, what do your employee relations look like? Happy, healthy employees are less likely to engage in violence at work. The factors that are listed on your screen right now primarily deal with type 3 violence. If you have a workforce that is understaffed and overworked, that's the type of atmosphere that might push someone who's on the brink of action to actually engage in the action. Poor management or supervision can sometimes be the root of workplace violence incidents. If you have employees who feel like they don't have adequate support, nowhere to go to voice their concerns, or no responses, that can sometimes end in aggression. Also, the lack of supervision can lead to missed pre-violent signals and warning signs, which we'll get into a bit later. Job elimination and reassignment. If there's a culture of fear of job loss, this can place stress on potentially unstable or otherwise violent employees. Inconsistent or inappropriate discipline, where you have employees feeling picked on, feeling treated differently than others. Lack of counseling and resources, and employee isolation can all contribute to a negative workplace atmosphere. And obviously, you may note that these sound like generally unpleasant working conditions to be in, and that's because there is a strong correlation between mental health, depression, negative environment, and violent acts. You can't change everything about a job, and you can't fit a job to every type of person, but there are some things that are within the employer's power to try to improve. With respect to the other three categories of violence, you really must consider the external conditions that affect the workplace and employees. Some primary ways to frame those external conditions are location factors. Are you in a high crime area? Are you very publicly accessible? And also looking at your customers and clients. Are you serving the ill or otherwise troubled customers? So in thinking about risk mitigation, it's important to understand some of the theories of employer liability for employee conduct and for workplace violence. In terms of what legal standards are placed on employees, the General Duty Clause of the OSH Act requires an employer to protect its employees against recognized hazards to safety and health. This clause does include workplace violence. There was a recent case that identified this issue of first impression. It was the case that's on your screen, Integra Health Management, involved a healthcare worker who was attacked by a client. The client had a history of mental illness and violent criminal behavior, including convictions for aggravated battery with a deadly weapon and aggravated assault with a weapon. But the employer, Integra, was unaware of this because it did not conduct any background checks on its clients. And the injured worker had submitted multiple reports to her supervisors in which she described disturbing behavior and stated that she was uncomfortable being alone with him in the house. And ultimately, to prove a violation under the OSH Act, there needs to be a condition or activity in the workplace that presented a hazard. The employer or the industry recognized that hazard. The hazard was causing or likely to cause death or serious physical harm, and a feasible and effective means existed to materially reduce the hazard. So the key under the OSHA standard is that the employer must address and prevent recognized dangers. Other than just the OSHA Act's General Duty Clause, negligence claims are a primary area of liability for workplace violence. These are the types of claims we most often discuss with clients who encounter workplace violence issues. It includes negligent hiring and retention and supervision. An employer can't be responsible for preventing all violence. That's impossible. Many things are unforeseeable. However, employers do have certain duties. Negligent hiring claims arise out of issues that the employer should have caught from the beginning of the employment relationship. It's a theory that's based on the employer's breach of common law and statutory duty to protect employees and customers from an individual they know or should have known posed a risk to others. Negligent retention and supervision is when something actually comes up in the course of employment and the employer fails to act. Now, some defenses to these claims do include unforeseeable events or superseding causes. The injury was caused by something unrelated to the employer's failure to exercise its duty of care. But you do need to be thoughtful and ensure you are exercising a reasonable duty of care. The key question is really, did you know or should you have known about the employee's violent propensities? Other common law claims at stake are emotional distress, wrongful discharge, wrongful death. And then, of course, there's intentional torts of assault, battery, and intentional infliction of emotional distress. However, an employer is only liable for those types of torts if they're committed within the scope of employment. That really means that the employer committed the act within the time and space limits of the employment relationship and was motivated, at least in some part, by a purpose of serving the employer. Your classic example there is the over-aggressive bouncer at a nightclub. All right, Chris, can you walk us through a few more concerns?
Right. Thank you, Becky. So Becky's just talked about employer liability arising from employee conduct. Let's talk about employer liability that can arise from problematic policies. First, claims arising out of an investigation. To be clear, a good faith, well-structured investigation is critical to successfully resolve any workplace violence issues and address any red flags that emerge. However, an overly intrusive or poorly managed investigation may give rise to certain legal claims, particularly for invasion of privacy and defamation. For example, defamation claims can arise out of a failure to maintain confidentiality of an investigation. Similarly, invasion of privacy claims can come up when an investigation goes too far or goes beyond the employer's legitimate need for information and becomes more intrusive than reasonably necessary. To avoid these types of claims, employers must implement some best practices in their investigations, Keep your investigations on a need-to-know basis. Always stick to the facts, both in your writing and your discussions. Try to avoid labels, subjective descriptions, and do not play armchair psychiatrist. Finally, understand your state's privacy laws when it comes to permissible investigation practices, and make sure you stick within those boundaries. Make sure your company's investigation policies are on the books and reflect the legal limits of your power as an employer. Later in the presentation, we will return to investigation best practices for a deeper dive. The next way employers can become legally liable for problematic policies is Title VII. For example, you may be faced with a female employee facing domestic violence, and you may worry that that domestic violence will spill over into the workplace, leading to workplace violence. However, if you were to fire that worker, you may wind up facing a Title VII sex discrimination claim. The proper response to domestic violence is to consider how to protect your employee and not to implement policies or decisions which can have the effect of punishing the victim. Relatedly, employers sometimes run the risk of not taking seriously domestic violence allegations when a male employee is the victim. Failure to believe a male employee about domestic violence, for example, his mental health impacts can lead to legal issues down the road. Similarly, certain states have paid leave laws for domestic abuse victims. Make sure to treat female and male employees equally under the law. Finally, consider how your policies can trigger disability discrimination concerns. These types of claims can arise from inquiries into an employee's mental or psychological conditions, or employers can get in trouble for acting on the basis of a real mental illness, a perceived mental illness, because of an employee's record of mental health treatment. When your policy and circumstances dictate that you must get into these topics, such as mental health and mental health history, make sure you identify and document your legitimate business reasons for doing so. Perhaps the strongest example comes to mind, an employee which poses a direct and immediate threat to coworkers. Remember, when acting, you must use objective evidence, the types of things that allow others to retrace your decision-making. Never act on perception alone. If you have a suspicion about an employee and lack objective evidence, gather more information. In the meantime, to protect your workforce, you may take preventative measures that the employee could not construe as directed towards them. For example, generally increasing the level of supervision or security. Switching gears, but remaining in the disability discrimination realm, consider how your response strategies account for disabilities. Consider that disabilities in your existing workforce and common disabilities that may arise may require you to change your response strategies to workplace violence. For example, alarm systems that rely only on sound put deaf workers at a disadvantage, or evacuation plans which depend on stairwells are impossible to the mobility impaired. Similarly, these workers may have issues relying on an evacuation plan which presupposes that everyone can run the exits. This is a non-exhaustive list for obvious reasons. The proper approach is to consider the composition and possible future composition of your workforce. You can consider using voluntary disability disclosure forms for your new and existing employees. This will allow you to build accommodations into your emergency response plans. Changing topics now, we want to talk about specific prevention policies, and the best way to frame this is to look at the big picture from three perspectives. The question of what is appropriate for you is ultimately a very individualized inquiry, but there is overlap between employers in the same industry or employers with similar external or internal pressures. To frame the prevention policies we want to discuss, let's talk about them from three major perspectives. First, the environmental. In other words, the physical conditions of your workplace. When you're discussing environmental, think about this in terms of the physical design of your workplace, including things like layout and size, but also things that influence how the environment appears. For example, inadequate lighting can be a danger by creating hiding places for potential threats. It also reduces visibility. Environment also includes things that are added into the environment, such as security systems, cameras, controlled exits and entries. Panic buttons are also a new component, although widely used in the banking and healthcare industries for decades, are making their way into new sectors. The second perspective we want to address is the organizational and administrative category. This can include the programs, policies, practices, and structure of your organization. Think of this not only in terms of the violence prevention policies and programs you adopt, but also the programs that generally influence your employees' health and mental well-being. This includes things such as adequate employee assistance programs. This category also includes whether you have strong employee training protocols on things like warning signs and emergency response procedures. The third perspective we'll talk about is the behavioral and interpersonal perspective. Now, this is how your workforce relates to itself. This is how employees communicate, interact, what things typically go said and unsaid, and how tension is created and resolved in the workplace. This also includes how your staff recognizes and responds to threats. This also includes whether your workplace culture supports things like reporting potential threats and red flags, or whether your workplace culture has a true concern over the mental health and well-being of others. The culture of your workplace sets norms. For example, if a certain level of unhappiness, stress, or anger is the norm for the workplace, then certain red flags may go unnoticed or unreported. Digging deeper into our first perspective, environmental, let's talk about two policies that all employers should consider. First, consider your workforce from the external risk factors perspective. Recall from our earlier discussion that external risk factors can include where your facility is located, whether you are in a remote or rural location, and the types of customers and clients you serve. There is a reason that many workplace violence studies are done in the healthcare industry. It's unavoidable when you're servicing certain customers and patients that a greater risk of workplace violence may emerge. The important thing for employers to consider is what you can improve given the conditions you cannot change. For example, you can almost always increase the level of security systems or the amount of security in a building. You may also consider things like lighting or even mirrors around corners. Also, restricted areas or badge access systems are a good way to improve environmental security. Sometimes it's a less technical solution. For example, a good question for any employer: if an employee asks for an escort out to his or her vehicle late at night, could you provide one? Sometimes it's a question of best practices within an industry. For example, the retail industry suffers from a relatively higher degree of type 1 workplace violence. Remember, this is strangers entering the workplace to commit violence. As a result, the retail industry has adopted certain practices that have been statistically shown to reduce workplace violence. These things include policies like limits on cash handling, drop safes, improved visibility, and effective lighting. Sometimes, instead of the industry you're in, the issue is your location. Many of our clients have workers in very remote and rural areas. For this type of workforce, one of the most important protections you have is your communication tools. Consider whether your employees have access to cell phones, satellite phones, or other ways to raise an alarm or get in touch with others. Consider how you can effectively communicate an emergency situation to your workforce in rural areas. Consider whether your workforce has been properly trained and understands the communication resources available to them. This training point cannot be restated enough. Your response tools are only good if your employees know that they are available for their use. Moving on, a related topic, consider your workforce and the work site and the readiness for emergency evacuations. This raises questions again about facility design. Do you have appropriate access? Do you have appropriate exits? Are there secure areas for refuge and hiding? Which doors lock and for what reasons? Who can unlock them and why? Can parts of your facility be locked down during an emergency? Who can open the locked areas and how? We will touch on this more later, but consider your mass alert system. This can be things like automated text messages or emails. We recommend that leveraging all communication channels simultaneously. This increases the odds that every employee will get the necessary information in time to take appropriate steps for their safety. Moving on to our second perspective, organizational and administrative, we want to talk about several policies in this area. First, one important step for any employer is implement a zero-tolerance policy for aggression. This must be a clearly defined policy which explains what conduct is prohibited. It's good to include threats and violence within this definition of prohibited conduct, but you also want to extend the definition to include precursor actions like intimidation, horseplay, harassment, and bullying. Make sure your definition of what is prohibited includes all forms of these activities. Consider what electronic communications you wish to prohibit. Set your standards in jokes and horseplay online. This policy must also set clear expectations on discipline. Discipline must be prompt, serious, and fair. It must be applied to all, no matter who is the perpetrator or who is the victim. Finally, make sure this policy is widely available and the workforce knows about updates. You may want to periodically remind your workforce about this policy, especially if you start to notice smaller issues emerging. Second, you'd like to create a strong weapons in the workplace policy. We generally recommend a policy which prohibits all weapons in the workplace. This includes guns, but also things like knives and other weapons. You should try to anticipate employee questions. For example, an employee might desire to bring a firearm to the office for protection. Generally, we do not recommend making this carve-out to allow employees to bring firearms into the office. Of course, most government agencies and the experts recommend a simple flowchart in case of workplace violence. Run, hide, and as a last resort, fight. To allow an employee to bring a weapon into work flips this flowchart on its head, and the statistics bear out the idea that if employees have access to firearms, even if they have good intentions, it leads to higher rates of workplace violence. Of course, you must know your state's laws. States generally allow employers to ban firearms within their buildings. However, a common statutory exception to the prohibition on firearms at work are what are known as parking lot laws. You'll see a map appearing on your screen. The red states are states which have passed some version of parking lot laws. Under these statutes, some employees are allowed to store lawfully possessed firearms or concealed handguns, and sometimes ammunition, in locked personal vehicles on employer property. You always need to be aware of what state laws you're working under and what those state laws allow and have created carve-outs for. If employees aren't allowed to possess ammunition but are allowed to possess firearms, make sure your policy covers that same carve-out exactly. Additionally, use signs when implementing weapon prohibition. These signs should cover employees, clients and customers, and the general public. Always be sure to know how your state regulates these signs and the important distinctions your state may make regarding things such as open and concealed carry.
Thanks, Chris. In addition to having those policies that clearly prohibit violence and weapons in the workplace, you also want to be able to take action to enforce those policies. Often what is required is the ability to conduct searches. So you need to have clear policies regarding workplace searches and inspections that track the laws in your state. If you don't have such a proper policy in place, you might encounter a situation where the facts really warrant a search, but you refrain from doing one because you're concerned about the invasion of privacy risks. In the event something were to later happen, which may have been prevented by a search, you could find yourself in a negligence claim situation. So your employees really must be aware that they do not have a reasonable expectation of privacy in the employer-provided spaces, such as offices, desks, lockers, and that you as the employer may search those areas for weapons, drugs, and other contraband. If you don't yet have this policy on the books and you implement one, make sure that all employees understand that new policy and are aware of it. You also want to know your ability to access employee vehicles on company property under various state laws. And make sure your employees are aware of this condition of employment before it becomes necessary to conduct such searches. Now, moving on from searches, we'd like to talk about a subject that spawns a lot of questions from our clients. How do I handle an employment termination where we have some concerns regarding the individual's reaction and potential aggressive tendencies? This comes up sometimes because an employer knows the individual is highly emotional and already has a lot of heavy issues going on. It might be because the employee has actually displayed aggressive tendencies at work. Or sometimes even if the employee has never made any type of threatening statements at work, The employee has been very open regarding their affinity for guns or the fact that he or she owns a lot of guns, particularly if you're in a state that permits guns in personal vehicles. That can be a concern prior to a termination meeting. We all know that terminations are never positive, happy meetings. They can lead to feelings of frustration and hostility, and sometimes those unfortunately escalate to violence. So you want to caution your supervisors against reacting in the heat of moment with terminating employees. Firing on the spot is never a good idea. And also, where possible, the termination shouldn't come as a complete surprise to the employee. This is where employers' progressive disciplinary actions can really be beneficial in helping the employee understand over a period of time why their performance was unacceptable. But obviously, that's not always the case. Some employee behavior warrants immediate termination. And regardless of whether this is a slow process or an immediate termination, you want to make sure that you have procedures in place for such terminations. You want to always assess the threat that you're looking at. Consider using a neutral manager. If there's a particular manager or supervisor who has been the object of the employee's anger or frustration or threats, that person should not be the person to conduct the termination. You also want to always wait until the end of the workday to terminate if possible. For one reason, many employees have already left the office, so in the event there is an incident, you would hopefully have less people in the workplace. Also, it helps provide the terminated employee a little bit more dignity if there's fewer people witnessing the termination meeting. You want to make sure that, particularly where you have a concern, you have some security nearby. Not in the same office. You certainly don't want to have a uniformed officer standing in the termination meeting. But if you have someone that's close enough to hear signs of a problem, they can take action. An important tip is to never allow the employee to take a break during a termination meeting. If an employee says, "This is heavy news, can I have a minute? I need to use the restroom," anything of that nature, let them know that you really need to finish the meeting first and you can wrap up quickly. And if they press and say, "I really think I'm going to be sick," or "I have to leave," you say, "That's fine. We'll go ahead and end the meeting and we can follow up anything necessary by telephone," and have them escorted out. You don't want to give them the opportunity to return to their desk or their vehicle to retrieve a weapon. You always want to minimize any reasons why the employee has to revisit the workplace, mail the check, have uncollected belongings sent to the person's home by a delivery service, and make sure you cut off all access immediately. Of course, you want to allow the terminated employee as much dignity as you possibly can, but your meeting needs to be brief and to the point. There shouldn't be a lot of back and forth or revisiting painful details of failures. You want to try to avoid feeding any of the anger, but you also want to let the employee vent a little bit if that's what appears to be the appropriate response. And lastly, it can be helpful to emphasize any severance benefits you might be offering, outsourcing. If your EAP system has access for former employees, things like that can really help in the meeting on a note where the individual doesn't feel so hopeless.
Thanks, Becky. And I just wanted to add one additional point. What we've been talking about are sort of terminations with the potential for hostility, but employers should have baseline procedures for every employee departure. You need minimum protocols and don't always trust your judgment or expectations about how it's going to go. Returning to an example we talked about earlier, the Virginia Beach shooting, a good protocol there would have been to secure employee key cards immediately upon resignation, no matter whether that employee resigned in good standing or whether that employee was terminated for cause. If employers set baseline procedures, they set a baseline level of safety, and these procedures should be uniformly applied no matter the circumstances.
That's a very good point. Thanks, Chris. All right, moving on, addressing some policies related to external threat risks. Domestic violence issues are something that, as we've mentioned, can creep into the workplace. You want to consider whether or not you want to have policies that encourage or potentially even require employees to report to you whether they have a protective order taken out. And in such case, you may want to provide a photo to the appropriate security or front desk in an effort to help prevent that individual from entering your workplace. You also might consider whether that employee is near a window or near the front of the door and whether it would make sense to move that person. And it's not just because you're looking out for that particular employee, but you're looking out for your entire workforce. If the aggravated person approaches the workspace and sees the individual through the window, decides they want to come in, they may, in fact, not just injure that employee, but your other employees. For that same reason, you might want to consider removing the employee from your public website, removing information regarding location or telephone calls. Other options you can consider are providing a well-lit parking spot near the building to that individual, pre-programming 911 on their cell phone, and things of that nature. And of course, always call the police if the abuser exhibits any criminal activity at your workplace, such as stalking. In terms of prevention, behavioral and interpersonal relations with your employees is key. Screening is key at the beginning of the employment relationship. You want to ensure that their application for employment looks appropriate. How did they fill it out? Did they leave questions unanswered? Did they leave personal references? Even if you don't end up calling the references, you would hope that they listed some, and it's sometimes concerning if they don't. Criminal background checks is a fairly standard part of the pre-employment process. And interviews, we recommend at least one full in-person interview so that you can get a sense of who it is that you're hiring. But of course, you always want to remember that an automatic exclusion of applicants with criminal records is inappropriate and can lead to Title VII disparate impact claims. You also want to work to promote mental health in your workplace. Recall some of the earlier work risk factors we discussed: understaffed, overworked employees, arbitrary discipline, things of that nature. Take steps to try to prevent such things, minimizing isolation and hostility, really fostering open communication and dialogue, offering your employees opportunities for professional development, and fostering a friendly work environment. You also want to make sure that your discipline systems are fair, uniform, and reliable, and that your supervisors know that and issue discipline consistently. Finally, you want to foster channels of communication that are non-judgmental and non-confrontational. Allow complaints to go both ways.
Okay, great. Thank you, Becky. So now let's take a deep dive into two of the most important foundational policies for any employer: the reporting program and the investigation program, beginning with reporting. So let's just first start off with the reporting program by discussing the warning signs that a reporting program should be targeted at identifying. At the outset, it's important to note that full participation in the reporting program is critical to its effectiveness. Therefore, these are the types of signs that must be known and understood by the workforce and not just the management of the company. The workforce must be educated on warning signs and educated on the procedures of the reporting program in order for the system to work. Now, research has indicated 3 levels of warning signs which increase in severity. First, an employee who refuses to cooperate or makes inappropriate or offensive comments, inappropriate conduct, or is overly negative in their tone or demeanor. Moving up, the second level is an employee who acts in a manner designed to upset or disturb others. This includes sabotaging equipment or physically acting out. At this level, the employee may begin to make threats of violence. The third level is an actual intent to harm. This includes an intent to harm which is actually carried out. You always want to be aware of the common stressors that can heighten the risk of violent behavior. As these stressors increase or magnify, the warning signs may increase as well. Common stressors include interpersonal conflicts, either at home or at work, employee illness, either mental or physical, an employee's loss of social support, including the loss of a loved one, financial losses or other hardship, and feelings of helplessness. Now, feelings of helplessness can be brought on by several factors. It can be brought on by work issues or personal difficulties. Feelings of helplessness are also related to employee illness. Consider a medical issue which makes an employee feel helpless. Moving on, let's dig deeper into the early warning signs. The key here is to always listen to your employees. Make sure their voices are heard and problems do not go ignored. Take note of changes in your employees, especially changes over time and worsening symptoms. Common early warning signs can include changes in the level of employee social interaction, improper emotional responses to everyday remarks, behavior that seems incongruous with their past activity or antisocial behavior. This can also include attendance issues, including commonly arriving late or leaving early. Decreased productivity can also be a red flag, including excessive mistakes or lack of attentiveness in the job. Changes in health or an employee's hygiene may indicate deeper symptoms. Also, substance abuse, including alcohol abuse, can be another common early warning sign. However, always know your employees. A red flag for one may be benign for another, and it's important to track what is going on over time. Always remember that your management can make resources available to employees going through common stressors or exhibiting early warning signs. Warning signs do not always lead to workplace violence. In appropriate cases, the employee can be directed to an employee assistance program or another resource, and these programs can provide professional evaluation and the opportunity to determine whether further treatment is necessary. In addition to using employee assistance programs, consider sending a troubled employee to a fitness for duty assessment. Through this, you can use a medical examiner to determine whether or not an employee has the capacity and capabilities to handle the requirements of the job. Remember that deteriorating mental conditions, especially when it results in danger to coworkers, can sometimes disqualify an employee for fitness for duty. When you do use fitness for duty exams, be wary of ADA risk in the process. Always document the symptoms you are acting upon, act fairly and uniformly, and always use objective evidence. Remember to pass along this documentation to the medical examiner conducting the exam so that you are assured the exam covers the correct topics. Always remember, as you monitor warning signs, address and document problematic behavior over time. We've harped on the benefits of documentation for multiple reasons already in this presentation. Just to highlight one additional reason, as your staff turns over time, or as an employee's problems slowly worsen, you won't lose your institutional knowledge of the situation. Moving on, continuing through our early indicators, and some of these might seem obvious but are worth mentioning. Does your employee frequently discuss violent topics such as violent crimes, suicide, revenge, negative emotions? Has their social media communications been erratic, obsessive, or otherwise troubling? Similarly, direct or veiled threats to harms are obvious warning signs. These are not always made in person. These threats commonly appear online through social media. Sort of taking a step back at the bigger picture, do you notice something about your employees' behavior that suggests they are not adapting well to setbacks or changes? Are minor warning signs growing worse or increasing in number over time? Document these warning signs so you can notice the trends that emerge. Patterns that emerge over time may not suggest themselves as warning flags in isolated incidents, but may require action when judged in totality. So, a common problem with reporting programs is the issue of underreporting. Underreporting is when an employee or multiple employees notice the warning signs but do not make a report. To give just one example, there was a shooting at a Lockheed Martin facility in 2003. All the coworkers in interviews admitted that the shooter was, quote, one of those kind of people. He was known to the office as the one that would go postal. Nothing was done to address this problematic behavior that everyone observed, and tragedy resulted. I just want to flip the script on a positive note. Last week in California, a hotel cook was arrested by police when the authorities discovered a stockpile of firearms, ammunition, and tactical gear in his home. The authorities were tipped off to the cook when a coworker alerted his hotel management that the cook had told him his plans to carry out a revenge attack against his employer. Given the cook's access to weapons and his level of pre-planning for the attack, This coworker's tip was probably the sole action which averted another mass shooting. Research identifies two major drivers which fuel the underreporting issue. One, fear of retaliation or other negative consequences, and two, the belief that the reporting system doesn't work and nothing will change. Other reasons underreporting occurs are employees assume that living with troubled coworkers is just part of the job. Other employees assume that a baseline level of anger or unhappiness is simply acceptable at work. Employees may think a coworker's threats are simply dark humor. Employees may be undertrained and do not understand the reporting system or understand the types of signs they should be identifying. Employees may want to protect each other and avoid wrongfully accusing. Part of the solution here is underscoring that a reporting system can serve as assistance. Warning signs are often an indication the employee needs help. And help can be things such as an employee action assistance program, and they're not always a punishment mechanism. Finally, as we saw in the Lockheed example, sometimes there's a collective action problem. When too many individuals are unaware of a problem, sometimes the responsibility becomes too diffuse. It's like a car wreck on the side of the highway where everyone passes by, assuming someone else will take responsibility and help out. Knowing what we are up against in terms of the underreporting problem, let's talk about the features of a successful reporting program that encourages full employee participation. First, your system should be clear, easy, and straightforward. Make sure employees know who to talk to and how. Make sure employees are aware that the system is easy. It should not be hard to make a report, and the individual making the report should not be wary of how much time making the report will take up. Employees should be confident in the protections associated with the reporting process. They should be confident that the process is anonymous, and employees should trust that they will not be exposed or identified. Employees should also be trust their report will be taken seriously, that the reports will be addressed and investigated. They should understand that the reporting system will protect them and find solutions for the troubled employee, such as engage them with employee assistance programs. They need to be confident that there's no retaliation, and you need to ensure as an employer that there are no negative repercussions that are possible from reporting. On a broader note, try to create a relaxed, open, and transparent work culture that would foster the idea that reporting is natural. In other words, that communicating your concerns about a coworker is a natural act. Employees need to always understand the scope of the reporting program and that everyone is expected to participate. Similarly, no one is expected to let warning signs slide. The goal of the reporting program is to create a comprehensive catalog of the warning signs as they emerge over time.
So once you've fostered that successful reporting program, you want to ensure that you have an investigation process that actually responds to those reports. You certainly don't want to go through all of those efforts with training your employees on looking for warning signs and reporting warning signs and then letting that fall on deaf ears. So when you receive a report of that nature, you need to assess what level of response is warranted. If there's an imminent threat, a swift review of the circumstances and removal of employee from the workplace may be warranted. If the concern does not appear quite so severe, you can take a slower investigation process. It may sometimes be appropriate in certain circumstances to put an employee on a leave of absence while you review the circumstances. And you need to be prepared to answer that employee's questions about why they're being placed on a leave. That's really a script that should be carefully and individually drafted for each circumstance. Some best practices related to your investigations would be private, confidential interviews, ensuring your reporters that they will be kept confidential. Obviously, there's always concerns about retaliation from a violent individual, and so employees are often scared to report things out of fear that that person will find out and inflict some violence on them. So ensuring that private, confidential process is imperative. Having clear and complete documentation that someone could go back to and understand your steps can be helpful. And retention of records. If there's lingering issues or legal liability, you'll want to be able to refer back to those. Making some conclusive findings on these claims should occur at the end of your investigation. Now, sometimes that's simply just that the reports could not be substantiated, not that they've been fully discredited, but some type of conclusive finding should be made. And then action plans to address real concerns. You also may want to consider whether or not it's appropriate to have any sort of security presence in your office while you're engaging in this investigation. If an investigation does yield concerns regarding violence, getting back to best practices associated with terminations, something that has changed over the course of my practice is doing a termination meeting always in person. Years ago, for a long time, that was considered best practice. It was a form of dignity. I should face-to-face give you this negative news. I should stand up and tell you about it. In this day and age, we don't always recommend in-person terminations. Telephonic termination meetings may be appropriate depending on the particular individual and level of threat. It's certainly not always recommended, but if you have actual concerns about an employee, do not feel like you have to bring them into the workplace or let them come to work in order to terminate them. That can be done over the telephone. Now, you need to think about preparing for the worst and responding to violence if it actually does occur in your workplace. What is your organization's plan for a crisis? Do you have one? Many employers have an emergency action plan that addresses only fire and natural disaster. Consider adding elements to address violence in the workplace to that emergency action plan. If you're an employer required to have an EAP under OSHA standards, that plan definitely should include a response to active shooter situations. The purpose of your EAP is to facilitate and organize employer and employee actions during workplace emergencies. That can include violence in the workplace. In drafting your EAP, think about practicalities. Do you provide security? Can every employee contact security? Do you have emergency alarm systems, panic buttons? If you have an emergency, how is it communicated to employees? And do your employees know how such emergencies will be communicated to them? Consider your employees with impairments, as Chris mentioned earlier. Think about whether you can lock sections of your workplace, and consider how you suspend operations and then resume operations. Who is your crisis management team? Who speaks to the press? And what resources are available after an event? And remember to periodically review and update protocols to stay up to date on the latest technology and communication. Provide training to your workforce so they know what they are to do in the event of an emergency. But you want to balance the need to provide a safe working environment with training programs that don't cause employees undue alarm or stress. We receive a lot of questions in this climate regarding active shooter training and whether that's something an employer should implement. I think the answer to that question requires some thoughtfulness about the nature of your work environment. For employers who are very accessible to the public, it may be a very beneficial preventative step. But for those who are more isolated with layers of separation from the public and security, perhaps high in a building with locked doors on every floor, it may not be right. And you also need to consider the potential risks associated with physical and emotional injury that are sometimes reported in conjunction with active shooter training. But generally speaking, employers should not wholly shy away from training employees regarding what they can do in the event of an attacker on the premises. The basic step is ensuring your employees are familiar with the types of warning systems you use in the event of an emergency and knowing where the exits are and how to evacuate. If you'd like to go a step further, but you don't quite want to do a full active shooter training, consider showing a safety video at the beginning of a safety meeting or other general meeting, or handing out some flyers on the subject and briefly discussing this issue. On this slide, we've compiled a mostly government-prepared resources, which contains two different videos. One video is prepared by READY, which is a national public service campaign designed to educate and empower the American people to prepare for, respond to, and mitigate emergencies. And it was actually filmed here in Houston. It's about a 5-minute video, and you could consider showing that at the beginning of a safety meeting. We've also linked to the National Institute for Occupational Safety and Health, which is a research agency focused on the study of worker and safety health. It's part of the US CDC. And their website contains a variety of information and even some training materials that you might consider. Other resources are the Department of Homeland Security, FEMA, and some from the American Red Cross. Obviously, when you review these resources, you really want to be thoughtful about how you might incorporate them into your training practices. But it's something that you can get a little bit touch your employee workforce on without having to undergo something as serious as a half-day active shooter training. Okay, I think that we've reached our hour. So for those of you who need to leave, we appreciate your time and we hope that this has been helpful. We will try to answer just a few questions as time allows. And once again, we do just have a final slide reminding you about saving these dates in November for our next webinar. So, Chris, one of our questions that has come in is, what about off-duty conduct? Something like domestic violence or a bar fight that I suppose the employer finds out about. Does the employer then have a duty to take some sort of action based off of that off-duty conduct?
Well, Becky, that's sort of a tricky question. There's not a one-size-fits-all answer, sort of based on the varying level of states' laws and what jurisdiction we're actually talking about. I guess we could start with an outline of some factors to consider. Certain states have laws that protect lawful off-duty conduct, and certain states have laws that prohibit an employer from acting solely on the basis of an arrest. Other states even regulate an employer's ability to act on the basis of a conviction. So you want to sort of look at what actually occurred, whether the employee was arrested, whether a conviction has resulted, and whether the conduct is lawful or unlawful under the laws of your state. If we're talking about a true bar fight or another act of violence, odds are we're not talking about lawful off-duty conduct. If you pair this with a legitimate business interest in protecting your workforce and shielding your workforce from violent coworkers, odds are you can begin to act. But at this stage, when you're only relying on sort of a hearsay out-of-work event, you should verify the information you received. You can consider calling law enforcement to find out more information. You should almost treat this as if you got an internal report about a red flag and sort of go through the stages of evidence gathering before you take any concrete actions on what you've heard. So, Becky, I'll send the next question to you. It involves social media. What should an employer do if an employee is complaining about inadequate safety measures online, or they're feeling unsafe because of safety measures or unsafe because of a particular scary coworker?
Yeah, that's a good question, Chris. I mean, so much of what employers deal with today is online activity. I think the first reaction I would have to that as an employer is ask yourself, why did this employee post on social media as opposed to coming and telling you? You know, we've talked so much about making sure employees know they should bring this to management's attention. And I would be concerned that they felt like, oh, I should just go post it on Facebook or Instagram as opposed to telling my manager. So, you know, consider whether your reporting and training policies have failed. But the next thing you want to do is certainly be responsive. If it comes to your attention in any way, you want to talk to that individual, understand why they have those concerns, potentially investigate if you need to. You know, you also want to consider the source sometimes. If that person who posted it is a disgruntled, perpetually unhappy employee, that might weigh in on how you respond to the issue. But you definitely want to go back to that employee, let them know it's come to your attention, that they have concerns, and talk to them about it. And lastly, anytime we're talking about social media, we also always need to remember the protections under the National Labor Relations Act for employees to talk about, you know, their terms and conditions of the workplace. So think about that as you might respond to an incident on social media. All right. Well, I think that really takes us to the end of our time today. Again, thank you so much for joining us, and we'll try to respond to other questions we weren't able to get to by email and provide presentation materials following the presentation. Thanks very much and have a great day.